No, you weren't.
Right, I mean, closest.
But I'm so excited to get to item 2 on the agenda, so I'm going to call the meeting to order so that we can dispense with item 1 on the agenda, which is the approval of the minutes from our last meeting on September 23rd. I assume everyone's had a chance to review them, and unless there are any comments, I'd like to just put it out for a vote. We have a motion to approve?
Yeah, some of them, couple minutes.
I second.
Sure.
Oh, you have, that's.
Thank you.
We have a second on the floor. Any opposition to approving the minutes? Wonderful. The minutes are approved. And now on to the marquee item for today's meeting. The honoring of our retired ILS board members, former Chief Judge Janet DiFiore and Joe Mariani. And I think I'll let Patricia lay out the groundwork and then I'll follow through after she's done.
Well, thank you very much. So on behalf of ILS, we put together a resolution for each of the former chief judge and for Joe. And if it's okay, I'd like to read the resolutions. I have a couple comments and then open up for other comments.
Sure.
Okay. So for the former chief judge, so I'm just going to read it. Whereas the New York State Office of Indigent Legal Services, ILS, is committed to its statutory mission to monitor, study, and make efforts to improve the quality of mandated representation. And whereas consistent with Executive Law Sections 832 and 833, ILS reports to and works closely with the Indigent Legal Services Board to execute our statutory mission. And whereas Chief Judge of the New York Court of Appeals, Janet DiFiore, has served as chair of the Indigent Legal Services Board since her confirmation as Chief Judge in 2016, during which time she never equivocated in her support of ILS and its mission. Whereas the Chief Judge was a strong and effective leader of the ILS Board, actively eliciting key information and diverse opinions to facilitate board deliberations and decision-making on behalf of ILS. And whereas throughout her tenure as chair, she led ILS through a legislative enactment of statewide public criminal defense reform, significantly increased funding to enable fulfillment of that reform, and the selection of ILS as second director. And whereas Chief Judge DiFiore ably led ILS through the unprecedented COVID-19 health crisis, working closely and effectively with the ILS leadership on taking steps to ensure the well-being and safety of ILS staff and ensuring that ILS could continue its vitally important work on improving the quality of public defense. Whereas she was deeply committed to improving the quality of all mandated representation, and because parental representation and family court had not been included in the statewide public criminal defense reforms, she took steps to remedy this by creating the Commission on Parental Legal Representation. And whereas Chief Judge DiFiore has consistently provided ILS leadership with sound advice and rock-solid protection from political interference, providing superb leadership for too often neglected public responsibility. And whereas it is only right and proper that the leadership and staff of ILS commemorate and honor extraordinary service by members of the Indigent Legal Services Board, now therefore be it resolved that ILS formally recognizes upon the occasion of her retirement from the New York Court of Appeals that in Chief Judge Janet DiFiore we had a board chair worthy of our highest esteem and appreciation. So. And I just want to say on a personal level, when I took over as the second ILS director, I was following in some pretty big shoes of the first ILS director. And the chief judge made me feel like these were shoes I could fill. And I cannot tell you how much that meant to me personally. And I think from the perspective of the agency, how much that inspired me to be, I hope, an effective leader and continue to be an effective leader of what is an incredible group of people who work for ILS as we work to further this really important mission. So on a very personal level, I want to thank you for your support and pushing me out there and I think making me be the best that I can be. So thank you. Should I go ahead with Joe's and then?
Yeah, it was so good the first time.
Okay, so I'll start with the second paragraph. Whereas consistent with executive law, sections 832 and 833, ILS reports to and works closely with Indigent Legal Services Board to execute its statutory mission. And whereas Joe Mariani has served as member of the ILS board since its creation in 2010, and was in attendance at the board's first meeting in November 2010. And whereas as board member, Joe was a key voice in the decision to nominate Bill Leahy as the first director of ILS, demonstrating the board's commitment to pursuing the statutory mission of ILS by selecting as its first director a lifelong public defender and a fearless advocate, deeply committed to quality representation. And whereas the great strength of the board is its incorporation of diverse experiences and perspectives, with each member dedicated to the goal of ensuring quality representation for all eligible people, and Joe consistently contributed vital local insights into board deliberations and decisions. And whereas Joe was instrumental in facilitating the implementation of the Tompkins-Schuyler Regional Assigned Counsel Program, which serves as a model for regionalization efforts across New York State. And whereas as board member for over 11 years, Joe has served during a time of incredible growth for ILS. Over his tenure on the board, he has helped shepherd ILS from an agency with no staff and a responsibility for dispersing $79 million a year to an agency with over 30 staff and continuing to grow, and the responsibility for dispersing over $400 million annually. And whereas Joe has been an unfailing source of wise advice and consistent support to 2 generations of ILS leadership, whereas it is only right and proper that the leadership and staff of ILS commemorate and honor extraordinary service by members of the ILS board, now therefore be it resolved that ILS formally recognizes upon the occasion of his resignation from the ILS board that Joe Mariani, we had a board member worthy of our highest esteem and appreciation. So thank you. With regard to Joe, I just want to quickly say, when I prepare staff for participating and presenting at ILS board meetings, I always tell them, we have a hot bench. And Joe, you've been a hot member of that hot bench. Always with really, really good comments, just very thoughtful questions that really prod us to think very carefully about what we're doing, and I know help the board make really good decisions on behalf of ILS. And I know personally it helps everybody at ILS in the work that we do. So I want to thank you for your over 10 years of service to the ILS board.
Thank you. I just want to say, I'm so glad you started talking about the feeling of disorientation and insecurity that comes along with stepping into a new space like this, because it was only a few short weeks ago that I felt that, but I very quickly came to realize that the work of this organization is absolutely vital to the proper functioning of our legal system, and the honor of serving on this board is more than just symbolic, more than just something to put on a CV. It is a civic mandate, a humanistic mandate that the mission of this organization be fulfilled. And we are obviously so lucky to have 2 such obviously dynamic and dedicated people to serve on the board. And your work here is going to be, both of you, Joe and Chief Janet, your work here is going to be remembered and honored for as long as this organization keeps moving forward. It's very easy to understand why the chief judge, being here, working with you, it's very easy to understand why the chief judge regularly, consistently, almost persistently called for an increase in funding for representation for the indigent, both in legal and family court proceedings. She understood that uh, it was a no-brainer, to coin a phrase, that we keep an eye on this funding and that the mission of this organization continue. And I will just say, now having a much better understanding of how busy Chief Judge DeFiore was throughout the term of her service on this board, I have nothing but the greatest respect for you, that you could maintain the level of commitment to this organization that you did. I will never be able to copy it, but I'm sure as hell gonna try. So thank you both, and I'm gonna open it up now for anyone else who'd like to say anything.
I don't know what you say, how much you can say about Judge Janet DeFiore. Your passion and commitment to us is just incredible. And I noticed that the first day you were here, presence and your ability to get along. We would have all these ideas, we would actually close on them. We all would, but we needed you. And it's hard to close. You're a closer. And I just have the utmost respect for you and what you did for the New York State judicial system overall has been incredible. We are a much better judicial system, so can't thank you.
Is there anyone else?
Express me.
Sure.
First, of course, thank you. And Joe, you and I now have a resolution. So thank you for that. But the truth is that I am so happy to have this opportunity first to be here with all of you, many of you in person, so that I can thank all of you for the wonderful work that has been produced by ILS, started by acknowledging executive and legislative branches of our government who established and initially funded ILS back in 2010. It's very easy to move very quickly to the staff here. My enormous, I cannot express adequately my enormous respect and admiration for the work that is done here under the leadership of Patricia Wharton, who has really magnificently transformed into a wonderful leader and transitioning into that leadership position so seamlessly and strong. And of course, before you, the inaugural director, Bill Leahy, who was a powerhouse in his own right, and the extraordinary staff that each one of you have really been privileged to lead. It's been wonderful to watch. And with respect to the staff, each and every one of them has exceeded all of our expectations. They have more than satisfied, they've exceeded the statutory mission that you referenced in that wonderful resolution that you read to the record. And as to the board and the board members here, you know, the chief judge, to the chief's point, has many responsibilities, complicated, difficult responsibilities to attend to. But I will say this in all sincerity, that my service on this board as chair was one of the highlights of the almost 7 years that I served in this position. We bonded very quickly at the board over our shared concern and sense of urgency for reform. And then we came together and coalesced to support the work that ILS, the really groundbreaking work that ILS was doing. And recently I was asked to organize my papers, and I came across my boxes of material on ILS. And I found something, and I want to take one moment of your time to read this into the record. It's something I read into the record at a similar meeting, bidding goodbye to a member, but it really is, it's worth repeating. There is no overstating how remarkable the transformation has been at ILS. In less than a decade, New York State went from failing to meet its constitutional obligation to provide effective assistance of counsel to indigent criminal defendants, to now setting the national standard for what a properly funded, high-quality public defense system should look like. This is a historic achievement. I reiterate that because of course it's true, but I also want to add to that. It is your work. Everyone in this room, everyone appearing remotely, it's your work. It's your dedication, it's your passion, it's your commitment. That's the catalyst for this achievement and the groundbreaking work that you have done. And all New Yorkers owe you, and I join with them, a debt of gratitude for your service and your commitment to making the system better. So I thank you, and I'm very humbled by the resolution and a better, more informed lawyer and public citizen now because of my work. So thank you.
Thank you, Chief. Joe, did you want to say anything?
If I could just, and I can't do any better than that in terms of my admiration and respect for the staff and the board. Just a couple of notes. First of all, I don't know if this means I don't have to do the J Cope training anymore or not. So maybe somebody can let me know about that. I spent a long time in government. I spent 40 years in local government in New York State. And I have said this before, and I will say it with equal sincerity. Serving on this board has been one of the greatest honors of my career. To be a part of what has happened over the last 12 years, to be a part of something that was so transformational and has done so much good. That's why I came to government 40 years ago, to help make things like this happen. And it is so rare when you can see something occur like this from beginning to end, from a piece of paper, a piece of legislation 12 years ago, to what we've accomplished today is really remarkable, especially when you think about how few people have been involved. The board, a small staff to begin with, expanding to a larger staff, but uniquely dedicated, smart, passionate, mission-driven. It's amazing what has happened over that period of time, and I'm very proud to be a part of it, as I am to be a part of an organization that has really defined how the state and its counties can work productively and respectfully together. That's always been a part of the culture of this organization and a part of the reason I'm so proud of having served on this board. So to all of my friends on the board and all of the staff that I've come to know and have enormous regard for, thank you very much for having the opportunity to serve with you, and I wish you all very well.
Thank you, Joe.
So we have something for the chief judge, and the same thing will be mailed to.
Oh, I was going to say, so are the resolutions in the mail?
At my family dinner.
Yours will be mailed.
Thank you.
Thank you, Chief.
Take care.
That was very nice.
Very nice.
I get the feeling that neither Joe nor Janet have any great need for yet another framed declaration, but this one I hope is meaningful to both of them, because it is such an important job that they did. So congratulations to both of them again. And now we will move on with the rest of our agenda for today, beginning with some updates from Patricia on the Harrell Herring settlement and the Upstate Family Defense Quality Improvement Caseload Reduction.
So both of these items, the board has been in the loop on consistently, and so these are just really brief updates With regards to the Harrell hearing settlement, as we first notified the board back in June, at the June meeting, in May, we had notified the Harrell hearing settlement parties that the state's failure to raise the assigned council statutory rates was starting to thwart successful implementation of the Harrell hearing settlement. And we identified 2 counties in particular, Onondaga and Schuyler, that were on the verge of, if not already out of compliance with the caseload standards and quality improvement initiatives in the settlement because of the failure to raise the assigned council rates. So we sent that letter to the parties in May. In response, the plaintiffs issued a notice of noncompliance, a formal notice of noncompliance that triggers section 11, or the remedy section of the settlement, which allowed for a period of negotiations between the plaintiffs and the state on how to solve this issue. ILS is not a party to the settlement, so we weren't necessarily involved in those negotiations. The settlement itself does allow for either of the parties to invite ILS to participate in the negotiations, either all of them or some of the negotiations. We were invited into some of the negotiation discussions, really for the limited purpose of providing information on what it would cost the state to double the assigned council rates in criminal cases in the 5 Harrell hearing settlement counties, and the legal mechanism by which the counties could actually pay those increased rates, right? Because they're set by statute, so you can't just pay increased rates without some, either a court order or a change to the statute. So we provided that information, and we tried to keep apprised of it, what was happening overall. Throughout the summer, the negotiations continued, and I think into the early fall. In early November, ILS learned that the negotiations had fallen apart, and that the plaintiffs in the state are no longer negotiating, and that there wasn't a resolution, an agreed upon resolution. So it's our understanding that the plaintiffs will be pursuing litigation. We don't know when that will happen or exactly what form, but we have been told that that is the next step for the plaintiffs. So we just wanted to keep you updated on that situation.
The state bar was just brought up action, and there was a successful action in New York City, I understand, so it's moving.
Yeah. Yeah.
Slowly.
Yeah, exactly. No, and I don't, in all the negotiations, it's my understanding, both with the negotiations for the settlement, but also the lawsuit in New York City, that nobody ever said the rates didn't need to be raised. I think there's uniform agreement that the rates need to be raised. I think the issue is exactly how that will happen.
Yes. I feel like it was a notion that was out there that maybe this issue had to get resolved through litigation due to inertia in the other
branches.
So you're right, it's moving forward one way or another.
And I can just state, that I see firsthand the extreme damage that it's doing in Onondaga County. I'm getting phone calls from judges, we've seen the protests, the rallies that have been held, and it's really impacting the litigants, the very litigants that we're trying to serve through all of this work, and it's debilitating. Is more than comes to mind, and just distressing. Yeah.
Can I ask a question? Because I don't know. So are the rates standard for all of New York State? And these 2 counties that are out of compliance?
For the settlement, there's 5 counties in the settlement. When we issued our letter, at that point, we identified 2 counties that were out of compliance, but said the remaining 3 counties were on the verge of being out of compliance. And we in our most recent caseload report, we identified that they're pretty much there. That in terms of really struggling with fully complying with caseload standards and quality improvement initiatives because they can't recruit enough attorneys to do these cases on our panels. And so, attorneys are having more cases than they should have, accepting more cases than they should have. And ACP administrators are more frequently than they would like, assigning cases to attorneys who don't have the requisite experience and training to handle a particular type of case.
Just so you know, we're going, it's close to 20 years now since the rates have been raised. And they weren't extremely generous to begin with. I mean, the number you always hear is $75 an hour.
So are the assigned counsel rates different from the 18B attorneys?
It's the same thing.
It's the same. Oh,
Yeah.
okay.
Yeah, those phrases are used interchangeably.
Oh, okay. So then let me throw another term in, right to counsel. Are those gonna be assigned attorneys or?
They have to get paid.
So, I mean, is that all one category?
The rates, if the right to counsel you're talking about is the proposed plan to go
Yes.
statewide right to counsel. for
Yes,
Litigants in like housing court, like we were talking
yes.
about. Or the New York City plan, those rates are set by those governmental bodies, and it's really, they don't actually set the salary for the attorneys. I don't think, they provide funding to the legal service providers in order for them to meet their contractual requirements to represent tenants in those courts. So I don't know exactly how the actual attorney rate gets set. They probably just pay them the same thing that they pay all the other attorneys who work for these legal service providers, such as the Legal Aid Society or Legal Services New York. So it's a little different. It's not a statutorily set rate, but
Close to it.
it's a lot like, you know.
Patricia, thank you for filling us in on that, because I'm observing the same thing in Erie County, CSAT's observing it's affecting who we help.
Yeah.
Well, I guess it's kind of good news. Bad news, good news.
Yeah,
Kind of
it's kind of a mix.
Yeah.
Yeah, but I think Judge Sapiric said it as that there's multiple pressure points now with, you know, more than one lawsuit now,
Right.
on this issue.
Mhm.
So,
Courts behind it as well, so
Sure.
it's going to be resolved eventually.
the second quick update is just, a reminder of the November 18th email that I sent to, county officials, mandated providers, and the board members regarding the Upstate Family Defense Quality Improvement and Caseload Reduction Grant. So as you know, we had 4.5 million in our AIDS locality funding this current budget year for improved quality representation of parents in family court matters. And we are dispersing that funding via a competitive process. Unfortunately, it's not enough for every county, and it's even, you know, through the competitive process, it's a small amount of funding for each of the counties that are that prevail in the competitive process, but it's still a step forward. And so we issued the RFP, I believe, in August, and by October, by the deadline that we had wished for, we were able to announce awards for 17 of the applicants. There were 24 applicants altogether, 24 counties applied. And the awards range from about $475,000 over 3 years, $475,000 over 3 years, to $750,000 over 3 years. And it's a geographic range of counties, and the funding will be used both for institutional providers and for assigned counsel programs, which we're happy to see. The grants currently are tentative pending OSC approval of the procurement record, which we're in the process of working on. But while it's pending, and because this is what we do at ILS, we work on parallel tracks. While that procurement record is pending, we're currently working with the awardees on finalizing budgets and work plans for their contracts, because these budgets and work plans essentially operationalize their proposal. And so we hope that by working on parallel tracks, that once the procurement record is approved, that we'll be able to issue those contracts very quickly so that the counties can start implementing the programs that they proposed. So we're very excited about this grant. It's an exciting time for ILS to see, you know, a small amount of aid to locality funding being used effectively to prove a track record of what we can accomplish with a state investment in improved quality parental legal representation. And so we'll be working closely with the awardees to ensure that that happens.
It's wonderful. Okay, thank you. Then we can move on to our next item, which is our, I'm sorry, I think I might have mentioned this before. I might have gone out of order, but we're going to hear from Carlin and Patricia again on statewide quality and caseload relief. Who's going to start?
So Caroline, are you ready to start? So Caroline Halpers is our senior researcher for the statewide implementation team.
All right. Good morning, everyone. Can you all see the slide?
Yes.
I'm putting it on the slideshow now. Let me see if that works. Yep. All right. Can you all see it and hear me? All right. Well, thank you, everyone, for the opportunity to speak during this board meeting. I really appreciate it. As Patricia said, my name is Caroline Cowpers, and I am the senior researcher on the statewide implementation team at ILS. And one of my responsibilities includes collecting data and writing the annual statewide caseload report. And Patricia asked me to discuss with you the highlights of the most recent annual reports on this topic. I would like to start by saying, please feel free to interrupt me while I'm talking, because if you have any questions, I don't mind answering them during my presentation. So here is the first highlight I would like to share with you. The total caseloads handled by providers of mandated criminal representation in the 52 non-HH counties outside New York City. Before I go into the chart's main findings, I would like to note that as of the year 2020, we started to measure providers' caseloads using the more refined 9 ILS caseload categories. However, for purposes of comparison, I converted these 9 categories back into the previously used, less refined categories of homicides and felonies in orange, misdemeanors and violations in gray, family court cases in yellow, and then appeals in blue. Now, what this chart shows you is that the total caseloads handled by all providers of mandated criminal representation in the 52 non-HH counties outside New York City was fairly consistent over the years 2012 through 2019. In 2020 and 21, the first and the second year of the COVID-19 pandemic, there was a significant decrease in the number of total cases compared to the year before the start of the COVID-19 pandemic. Specifically, from about 328,000 cases in 2019 to about 198,000 cases in 2020, which was an almost 40% decrease compared to 2019. And then to about 212,000 cases in 2021, which was roughly a 35% decrease compared to 2019. So in last year's report, we speculated that the decrease in cases from 2019 was likely attributable to the COVID-19 pandemic, because stay-at-home orders and business closures drove down the number of arrests, and court adjournments drove down new case assignments. And then with the relaxation of COVID-19 protocols in 2021, it is not a surprise that provider caseloads increased slightly. Now, as we monitor caseloads over time, we will be better positioned to assess if provider caseloads continue to remain lower than in 2019, and if so, possible explanations other than the pandemic. Other explanations for the decrease could, for instance, include criminal legal system reform measures, such as the 2020 enactment of the Marijuana and Taxation Act, which legalized the possession of marijuana for recreational use, and the 2019 enactment of the Driver's License Reform Act, which limited the circumstances in which a person's driver's license could be suspended and thereby potentially diminishing the frequency of arrests for driving without a valid driver's license. Let's see. The charts on this slide present the exact same caseload information as the previous slide, however, then split out for institutional providers on the left and assigned counsel programs on the right. And the main finding that can be deduced from these charts is that the number of total cases in 2020 and 2021 went down significantly for both institutional providers as well as assigned counsel programs compared to the pre-pandemic year of 2019. However, we see a sharp decrease in the total number of cases handled by ACPs, which was a 50% decrease overall in 2020 and a 45% decrease overall in 2021 when compared to 2019. That for institutional providers, for which the decrease was 33% in 2020 and 30% in 2021 compared to 19. So in other words, it seems that assigned counsel programs in the 52 non-HH counties outside New York City seem to be hit harder by the pandemic than the institutional providers when it comes to the decrease in the total number of cases handled. The next couple of slides and charts show trends in provider staffing patterns. And this chart here presents the total number of full-time equivalent attorney staff in blue and non-attorney staff in orange in institutional providers in the 52 non-HH counties outside New York City. And it includes both criminal as well as family court staff. And based on this chart, we can conclude that from 2012 to 2021, there is a substantial increase in attorney staff from 506 FTEs in 2012 to 747 FTEs in 2021. Similarly, from 2012 to 2021, there's also a substantial increase in non-attorneys from 228 in 2012 to 383 in 2021. And as you can see, the increase in attorney staffing continued even during the COVID-19 pandemic. Again, these numbers include both criminal as well as family court staffing. And I would like to mention that the incremental increases shown in this chart reflect not only statewide funding, ILS distribution funding, non-distribution funding, and CAFA funding also contributed to increased staff. We see a similar multi-year trend in institutional providers in New York City. So from 2017 to 2021, there's a substantial increase in attorney staff from 1,180 FTEs in 2017 to 1,367 FTEs in 2021. And similarly, from 2017 to 2021, there's also a substantial increase in non-attorney staff from 534 in 17 to 812 in 21. Although the increase in attorney and non-attorney staffing in institutional providers in New York City continued during the COVID-19 pandemic, this chart also shows that this increase slowed down substantially. Moreover, had there not been a pandemic, including pandemic-related hiring freezes, we would have seen a sharper increase in staffing. And we actually know from our implementation work that providers have issues with recruitment and with retention of staff. And Patricia, you wanted to talk a little bit more about that here. So.
And I would say both for the counties outside of New York City as well as New York City, We had hoped with the statewide implementation that we would see an even greater increase in the number of staff starting in 2019 than what we're actually seeing. So as Caroline said, the increase in 2019, 2020, 21 isn't as high as we would like to see it. And we think there's a couple of reasons for that. One, of course, is COVID. And in some ways, the fact that the increases continue at all is a reflection of just how resilient statewide implementation has been despite, this unprecedented public health crisis. But the other issue that has emerged and that emerged in the data for this report, when you dig down deep into the data, if you look at it county by county, provider by provider, we realize that some providers actually lost staff over the past year. And that's, despite the fact that there's no longer hiring freezes. We, in our communication with providers in a recent meeting that ILS had with our Criminal Defense Advisory Group, what we're learning is that across New York, providers are facing the same problem that public sector employees are facing across the nation, which is it's becoming harder to recruit and to retain attorneys in these not-for-profit types of settings. And so, we're working with defense providers on solutions to this issue. But, we're aware of it and wanted to make sure the board is aware of it. And we've been quite honest about it in our report. We highlighted this issue in our report. It is something that if we're to realize full implementation, both of the settlement and its extension statewide, we have to be attentive to. And we have to think of strategies for addressing this issue, including the reality that defense attorneys for years have been underpaid, both as assigned counsel attorneys and institutional providers. And it's time for us to think about what that means and the implications of that, and starting to really think of, what a true living wage would look like, both for full-time attorneys and for assigned counsel attorneys.
Patricia, let me ask a question. One of the things that we saw was that when we were able to do virtual, we had more attorneys. When they mandated them to be in person, that's when we kind of lost.
Yeah.
So do you see that? They want to do virtual as opposed to being in the courtroom.
Well, ILS's position has been and will continue to be that that the quality of representation suffers when court appearances are done virtually, particularly if they're court appearances that have some significant event happening. And so, for example, arraignments, it's critical that these be done in person. We do not believe that the solution to the attorney crisis is diminishing the quality of representation through virtual court appearances. The solution is bolstering salaries, better recruitment efforts, as well as other strategies to ensure that you have enough attorneys. So, and I know for many of the arraignments in Westchester County, they're done by assigned counsel program attorneys, and to me, one of the key solutions is recruiting more attorneys and making sure that they're given a living wage. So
I'm just going to second that comment by saying, we've had a lot of experience now with virtual proceedings. Arraignments are there are many reasons why those have to be in person, constitutional reasons. But even with case conferencing in criminal matters, we've noticed in New York City that cases resolve, we try to get cases to resolve through the conferencing process. We obviously don't want cases that don't need to go to trial to go to trial. And we've noticed that the resolution rates go down by about 50% when we do these hearings virtually. There's something about the magic of being in the room that just facilitates that kind of, whatever it is, cooperation or whatever dynamic is needed to make these cases resolve. So there are a lot of good reasons, and I agree with you that attorneys tend to prefer to be doing their work from home, but there are a lot of good reasons why it works better when we're in court.
And I think that makes so much sense. You know, working in a criminal court for decades, it's got to be in person. That's when things get done. Now with civil cases,
Yeah.
it's really,
It's a little different.
it's very different, and remote does work. I'm not sure if it's great for the lawyers or not, particularly new lawyers. But I think with this recruitment issue, everyone's suffering from it, whether it's the courts or business or whatever. And part of it's wage. Well, next part of COVID, pay us what we deserve, although it's been an issue. Our, lawyers for a long time. And just other new ideas, how to get them back. I think we will. I think this is going to be a cycle. And I think once we get a little further away from COVID, whenever that is, and people really need jobs and are dedicated to representing the indigent, and we get the pay that we should get for them, it'll come back. But I think right now it's tough. I think it's tough for everybody. I know my sister in business had the same issue. Gotta pay people what they deserve, or you're not gonna get it.
I just want to reiterate what Patricia said. I couldn't agree with you more in the way in which you put it. In terms of, the in-person versus virtual, I think the fact that the courts had to conduct themselves virtually, I'm speaking from the attorney position, there could be some potential benefits to that, but I think those have to be offered with certain parameters. But with the default perhaps being, that in person, because I'm thinking about, and we know that, attorneys, would prefer in person for the most part. But I'm also thinking about when we're taking into consideration who we're trying to serve, what is better for that population. And particularly with the multifaceted needs that present themselves when they appear in court, I wonder, I see that their ability to be there and be able to talk to people, go outside of the courtroom, maybe have a conversation with service providers, it then lays the groundwork for them to be more successful. And I'm speaking from the civil side, obviously, so, and I wouldn't say that, there shouldn't be any allowance made for virtual appearance, especially for working people who, and for people who are having difficulty with transportation. I think about daycare issues, things of that nature. But I think there's a great need for that connection from the litigant's perspective.
Thank you.
Caroline?
All right. So next, we looked at the trend in provider expenditures, and this chart shows the total spending by institutional providers in orange and assigned council programs in blue for the 57 counties inside New York City, so including the 5 settlement counties as well. And we include the 5 settlement counties here, as opposed to in any other chart I've shown you so far, because in earlier years, no way of separating HH from non-HH counties. And therefore, this is the best depiction of the trend in expenditures over the past 10 years. The main findings here are that the total spending in the 57 counties outside New York City consistently increased from about 166 million for all providers in 2012 to about 236 million in 2019. In 2020, the first year of the pandemic, total spending decreased to about 215.6 million. And in 2021, it went back up to about 228.6 million. However, it becomes interesting when we look at institutional providers and assigned counsel program spending separately. During the pandemic, institutional providers' expenditures continued to increase from about 142 million in the pre-pandemic year of 2019 to 149 million in 2012 and 156 million in 2021. Yet for assigned council programs, expenditures went down during the pandemic from about 94 million in 2019 to 69 million in 2020, and then back up to 72 million in 2021. In other words, the decline in overall expenditures is attributable to ACPs, assigned council programs, and total spending in ACPs in 2021 is still significantly down when compared to the pre-pandemic year 2018. So how do we explain these findings? Well, it's likely due to the difference in organizational structure between institutional providers and assigned council programs. First, the decrease in assigned council programs expenditures compared to the marked increase in institutional providers expenditures is driven by the sharp reduction in caseloads in is driven by the reduction in caseload that the assigned council programs experienced in 2020 as compared to 2019. And since assigned council program attorneys are paid per case, unlike institutional providers, the decrease in number of cases impacted assigned council program expenditures. And second, and relatedly, the slowdown in case processing also impacted assigned billing. Assigned council attorneys are paid for the hours they work and subsequently billed, most often at the completion of a case. And during the COVID-19 pandemic, assigned council attorneys worked fewer hours, not only to the case assignments, but also because of the limitations in court functioning or barriers to in-person contact with the client. There was a slowdown in case processing, and fewer cases being resolved means fewer vouchers being submitted for payment. All right. So the last 3 slides include our actual measures of the success of statewide implementation of the Harrell Herring reforms. And to measure implementation success, we use 2 measures, one for institutional providers and one for assigned council programs. On this slide, I calculate the overall average number of weighted cases per attorney in institutional providers in 52 non-HH counties outside New York City. And we do that by dividing the total number of weighted cases by the total number of attorney staff in fully equivalents. And the term weighted cases refers to an adjustment that is applied to the caseload numbers of individual providers. For this chart, and to best assess caseload trends over time, caseloads are weighted based on the NAC standards as follows. Misdemeanors and violations are weighted at 1. Felony cases are weighted at 2.67. Family court trial cases are also weighted at 2.67, and appeals are weighted at 16. So this figure is the best depiction of the trend in weighted cases per attorney over time, over the past 10 years. And again, as I did for some previous charts for 2020 and 2021, I converted the more refined 9 ILS caseload categories to the previously used 4 categories for purposes of comparison. So what is the baseline here? Well, what we see is that between 2012 to 2019, there was a significant drop in the number of weighted cases per attorney in the 52 non-HH counties outside New York City, from 708 to 519. And this drop is primarily attributable to increased attorney staffing in institutional providers. In 2020, first year of the COVID-19 pandemic, and 2021, the second year, we see an even more significant drop in the number of weighted cases per attorney. And this drop is due to both the significant drop in the total number of cases handled by institutional providers during the pandemic, as well as the increase in staffing. Although, as we discussed, this increase in staffing was not as much as we had hoped for due to the pandemic. Now, please note that this chart includes criminal as well as family court cases and attorney staff. And that is important because the next 2 charts present the weighted numbers separately for criminal and family court. We were able to do that as of 2020 because we started using the more refined 9 ILS caseload categories. Also, in contrast to the previous chart, these charts include New York City, and therefore these charts give a more accurate view of caseload compliance in institutional providers and assigned counsel programs statewide. So on this slide, we again calculate the overall average number of weighted cases per attorney in institutional providers in the 52 non-HH counties and New York City by dividing the total number of weighted cases by the total number of attorney staff in full-time equivalents. Here, however, the total number of weighted cases is calculated using the more refined ILS caseload categories and their corresponding weights. And moreover, as you can see, weighted cases per attorney are calculated separately for criminal and family court. And what we see here is that the weighted criminal cases per attorney in blue went up slightly between 2020 and 2021 from 210 to 226. The weighted family court cases per attorney in orange went up as well from 373 to 390. This uptick is driven by two factors, the increase in case processing and new case assignments as COVID-19 protections relaxed in 2021, and many providers experiencing staff attrition issues, as described by Patricia earlier. Now, the difference is the weighted cases per attorney for criminal versus family court is striking. From an aggregate view, the target number, average weighted cases per attorney in institutional providers is 300. So this chart shows that in terms of criminal cases, the state as a whole is in caseload compliance. It also shows that family court defense attorneys were having to contend with much higher caseloads in 2020 and 2021 compared to criminal court defense attorneys. As you know, statewide implementation has focused funding and resources exclusively on criminal court representation, and mandated family court representation has not had the same commitment of state funding, and as a result, continues to suffer high-weighted caseloads per attorney. And then my last slide over here, as I said before, for assigned counsel programs, we use a different measure, a different approach, one that reflects how assigned counsel programs are organizationally distinct from institutional providers. So for this type of providers, we present the average spending per weighted case by dividing the overall total expenditures of ACPs by the total number of weighted cases. And for the weighted cases, we again use case weights in accord with the more refined 9 ILS caseload scale. Now, this assessment reveals the following. The 2021 average spending per weighted criminal case was $579, while the average spending per weighted family court case was $219. Compared to 2020, the average spending per weighted criminal case increased significantly, while the average spending per weighted family court case decreased. And as a result of statewide implementation, assigned counsel attorneys have more resources available to them to provide quality representation. The increase in average spending per criminal case between 2020 and 2021 demonstrates that assigned counsel attorneys are increasingly using these resources, showing progress toward improving the quality of representation provided. So in conclusion, when we view the disparities between criminal court and family court shown in the last two slides through a criminal defense lens, it highlights the progress that can be made when there is a state fiscal commitment to improve quality, attorney caseloads are lower, and spending per case is higher. However, when viewed through the parental representation lens, this disparity highlights what happens when there is no such state commitment. Defense attorneys continue to work under increasingly high caseloads with insufficient resources, and low-income parents in crisis do not receive quality representation. All right, that was it for me now. Thank you, and I'm open to any questions you would have.
I just wanted to emphasize those last two slides because they really show, the value of the state funding for improved quality representation. It does, when compared to family court representation, lead to attorneys having, a less overwhelming caseload, right? And to assign counsel attorneys having more resources and time to spend on cases. And that's very important. But it also shows that when you don't have that state commitment to improve quality representation, which we currently don't have in the family court area, attorneys continue to suffer under buckling caseloads. And the assigned counsel attorneys don't have the time and resources to spend on cases, so the amount they're spending per case on average is much lower than in criminal cases. So, in some ways, these last two slides, I think, are the most, their charts are the last two charts in the report. From my perspective, to some extent, they're the most important part of the report because they really show that, simultaneously two things: the value of a state commitment to improvement and what happens when that state commitment is lacking.
It's a pretty distressing picture when you compare the two slides.
Yeah.
Excellent report. Yeah, excellent report.
Yeah.
So there goes to Patricia, our efforts to focus more on family.
We have to walk and chew gum at the same time, and we have to continue to work with the statewide implementation and continue, identify the barriers, which the report does talk about, and push forward strategically and persistently, while simultaneously continuing to work hard to get the state commitment needed to the state fiscal commitment needed to improving the quality of parental representation.
Where we were with criminal years and years ago with the board. And how about the new governor? Is that a part of this?
We'll see this budget session.
But I mean, I would think that there's some room there.
I hope so.
Call is out there again, right? So.
Well, there's no doubt that part of this is additional funding that's needed. I total agreement, but I also think about a lot of the things that were happening on the criminal side that were also put into place alongside the money, like the mentorship, the sense of community. I think those, the implementation of that needs to be mirrored with family law, I think especially because in family law, and speaking personally, there's a great deal more strategizing that you need to do, on behalf of family and pulling in resources from various avenues, which I'm not saying doesn't happen on the family side, but certainly on the family side, and sometimes for more individuals than just the one, right? It's a whole family. So being able to create that community and have that mentorship, I think is also going to be key. So maybe borrowing what was done well in the criminal context and trying to implement it and mirror it in the family context. Because as we know, it's really challenging work that can become very isolating. And that's how we also lose people from, all of the pitfalls of that.
We agree.
So,
I agree with everything you say, and I have to say, and it's not based on numbers or something, but I have this concern that there's a window for that kind of mentorship relationship, teaching relationship, as the roles of assigned counsel suffer attrition. Whether there are going to be enough people around to sort of pass on that knowledge is a big question mark, and I think it just only adds to the urgency of getting new counsel brought in to these programs. Okay, thank you very much both. That really was an excellent report. Thank you, Carla. It was very illuminating. I think Burton's going to give us some updates now. Do I recall correctly that you were out with COVID last time?
I was, indeed.
Okay.
So, tested this morning. So thank you. I really enjoy these opportunities to report to the board on some of the hiring that we're doing and reflect on the growth of our agency. And I think it dovetails nicely with Caroline's presentation, because this is how we're going to be able to continue the work that's been accomplished so far. And as Patricia said, you know, we're adding more gum chewers and walkers every day. So since the last board meeting, we've added 2 new members to ILS, who I mentioned at the last meeting. Mandy Jaramillo is our new senior appellate attorney for the statewide appellate support center, and Kelly Egan is an appellate attorney with the center. So they've come on board since the last meeting. I can also announce 2 more additions to our new statewide appellate support center staff, who will be joining us in early January. Emily Lusignan is an appellate attorney. She most recently served as a principal law clerk for Albany County Supreme Court Justice Denise Hartman. She's also had experience as assistant public defender and the Alternatives to Incarceration coordinator for the Schenectady County Public Defender's Office. And then we've got Daniel Speranza, who's the junior appellate attorney for the statewide appellate support center. Daniel has experience working as an assistant public defender in the Albany County Public Defender's Office, and most recently is working in private practice. I think we were all very impressed with the energy, enthusiasm, and creativity that these candidates expressed for the work that they've been doing at the support center. So we're really looking forward to them starting and hitting the ground running in January. I can also report today that we have made offers to candidates for 2 positions that have been accepted. We have made an offer to a candidate for the assistant counsel for parental representation position, which is backfilling Lucy McCarthy, who you all met at the last meeting. She became director, her assistant counsel position became open. We have a candidate who's accepted that offer. We can't announce who they are yet, because they still have to go through all of the paperwork on the on the front end. But at the next meeting, I'm certain we'll be able to announce who they are. Similarly, we have made an offer for a paralegal for the statewide appellate support center, and they will similarly have started by the time we meet. In addition, we are currently in the interview process for candidates for an additional appellate attorney position for the statewide appellate support center, a family court senior research associate who will be doing work very similar to what Caroline does on the statewide implementation team, but for the family court unit, and the attorney in charge of our Western New York Regional Support Center. So those are interviews that are ongoing right now. And again, by the next meeting, we should have updates for you on all of those. And as if that wasn't enough, we are actively recruiting right now, posting and accepting applications for an investigator for our statewide appellate support center, 4 positions with our grants unit, 2 assistant grants manager positions, a grant administrator and a contract manager. And we're also currently recruiting for an assistant manager of information services to help out Peter Avery, who's done such a remarkable job handling our IT infrastructure since the very early days of this agency. But as we continue to grow, we want to lend Peter some assistance. So we're going to add that assistant manager position. And we've received the civil service exemption approval for all 6 of the Western New York Regional Support Center staff, including that attorney in charge position that I mentioned earlier. So it's very exciting. I think in the resolution for Joe Mariani that Patricia read, she noted that I think at the point where Joe officially stepped down from the board, I think we were at about 32 full-time employees at ILS. Once we have backfilled the open positions and hired and brought on everyone that I just mentioned here, I just had our administrative officer, Christine Becker, do some quick math for us. We'll be up to 57 I'm totally happy.
Now, in that scenario, correlation does not equal causation, right? It's not because Joe Mariano stepped down.
You know, I can't attribute, I'll leave that to the researchers to set me straight.
Okay.
I think that's right.
But that's pretty impressive.
And then finally, very quick update on the Western New York Regional Support Center office. Since the last meeting, we have executed the lease for that location in Buffalo. We're very excited about that, and agency staff is currently meeting on a weekly basis with representatives from the State Office of Information Technology Services, State Office of General Services, and the landlord of the building to make sure that all of the build-outs in IT infrastructure that are necessary occur in time for us to move in for an estimated move-in date in spring of 2023. That is the update.
Nicely done. Thank you. That was inspiring. Is there any other business that anyone would like to raise before we adjourn today's meeting? Then I will just point out for everyone that the 2023 meetings are listed on the agenda for April, June, September, and December of next year. I want to thank everyone for coming today and participating. This was a very nice meeting. Last one was a little more daunting, at least for me.
And me.
But I once again just want to reiterate how much I admire and respect the work that you all do, and I wish you all wonderful holidays and a very, very happy New Year. Thank you.
First one, hope will be with us next meeting.
Thank you. All right, then we are adjourned.
Thank you. Thank you.
Thank you.
And lunch is served.